Court is now in session. You may be seated.
SJC-10431 Canton versus Commissioner Mass Highway Department.
Good morning, Mr. Stevens.
Morning. If it please the Court, John Stevens for the Town of Canton. The issue before the Court in this case is whether the town's challenge to the adequacy of the environmental reviews of CCF's Westwood Station project is timely. Specifically, whether that challenge was filed within 30 days after the first issuance of a permit.
Let me ask you if I could, Mr. Stevens, do you essentially concede that Sierra Club doesn't consider the statute of limitations issue with which we're here concerned?
We agree that the statute of limitations provision was not there at issue, but the Court provided guidance to parties as to when a challenge such as that brought by Canton could first be brought, and therefore it informs the Court's decision and certainly the actions of the parties with regard to when they commenced.
Doesn't it just say in a footnote that it was brought within the first permit to issue?
It said not in a footnote, but in text, in dealing with a standing argument that the issue was not ripe for review because it had been brought before the issuance of the permit from which environmental harm was anticipated to occur. But the Court nonetheless went on to address the merits in its discretion, suggesting since the action was not ripe, it did not have to address it, and the parties had no right to require it to address that issue. I would like to make...
Now, let me ask you this. How does it help you if the sewer permit were not the first permit to be issued, but the other one, the determination, the DEP authorizing the use of the paint crushed rubble, the beneficial use determination? That doesn't help you. That just makes your claim even later.
What we are saying is that the characteristics surrounding that permit, which is the first of any permits to be issued, demonstrates even more strongly the unjust result that obtains if any permit, however secret, however unanticipated, however illegally issued, however irrelevant to any fears of environmental harm, is held to foreclose anybody's right to review of the adequacy of MEPA determinations. And in fact, there is no party before the Court who's
taken a consistent position.
Who urges that
the first permit is the first
exactly,
permit.
that everybody says it means something else, and what it means should be determined in a statutory context. Now, I'd like to address that.
Well, is the question whether that first beneficial determination, whether that was a permit?
It was a permit, but it was not a permit that is implicated by the phrase first issuance of a permit in Section 62H.
Why?
Because, as I just said, it is recognized that that statute of limitations refers not to any permit whatsoever, but only to particular types of permits.
Well, that's your argument. That's your argument.
It is also the CCF and the court below looked at the second permit, not the first permit. They recognized that that first permit is not the type of action that could justly cut off rights. The Attorney General, the Commonwealth, argues with a conceptual underpinning that the legislature argues, like Canton, that the legislature intended the phrase first issuance of a permit to refer only to certain categories of permits. The Commonwealth would say it refers to permits that are listed in the Secretary's certificate on the final environmental impact report. Canton's view, more closely attuned to the statute, is that the phrase first issuance of a permit refers to permits that first relate to the subject matter the legislature requires to be specified in a notice of intent to sue, and second, are issued in compliance with law, that illegal actions should not cut off legal rights. And as I said, Canton's categorization of the permits implicated by the phrase first issuance of a permit is truer to the statute than the Commonwealth's. The Commonwealth, once again, says the category of permits the legislature intended to refer to were those listed in the Secretary's certificate on the EIR. Well, the statute itself does not require that permits be listed in the Secretary's certificate on the EIR. It does not even require that the Secretary prepare a certificate on the EIR.
So then why don't we just interpret it as first permit, which is what it says?
Because, Your Honor, that would produce just results, and it's not consistent with the statutory scheme.
You mean unjust results?
Unjust results. Thank you, Your Honor. Canton's categorization is consistent with the statutory scheme in the very same section of the Act that contains the phrase first issuance of a permit. The legislature specifically directed that anybody, any party who is planning to challenge the sufficiency of environmental reviews for a project file a notice of intent to sue, which, to quote the statute, shall identify with particularity the issues to be considered in such action or proceeding. In three sections earlier, in Section 62C, the legislature also specifically required that, and once again I quote, at least twice per month, the Secretary shall issue notice of all filings received during the preceding half month in such form as the Secretary shall determine is reasonably suited to informing all interested persons of the receipt of such filings. The bi-monthly publication the Secretary chose to carry out that statutory directive was the Environmental Monitor. And Section 61 findings that are required to support permits are to be filed. In other words, the legislature required that Section 61, that in order to be a legally issued permit, the underlying Section 61 filings must be published in the Environmental Monitor.
But there are administrative ways of punishing or of going after the agency for not doing what it's supposed to do. Why does that affect what you're supposed to do?
Well, we are relying on the fact that we will receive legally, legislatively prescribed notice of these actions.
But you're, as far as I can tell, that's an argument in this case, but you say, in fact, that doesn't matter because the only permit that matters, given your traffic interest, is the highway.
Yes,
so it doesn't matter whether they complied with Section 61 or got it in the monitor or not. From your perspective, can I ask you a question about your perspective?
Certainly.
Which is, how does that interpretation, besides seems to me avoiding the word first, permit issued, but how does that go along with the purpose of the 1977 amendments to MEPA to make it an expeditious process, because your interest could be way down the line in terms of the development of this project?
Let me turn to that issue, Your Honor. The CCF's argument and that of the Commonwealth is based on the erroneous assumptions that opponents of a particular project will inevitably file a lawsuit, so that expedition demands that these lawsuits be required to be filed as soon as possible so that they can be resolved as soon as possible. That's their argument, and that's what Your Honor is asking me to address. Well, let's look at Canton's claim. The essence of Canton's claim is that the commissioner was proposing to allow the impacts of tens of thousands of vehicle trips on the town of Canton without requiring in Section 61 findings adequate all feasible mitigation for those traffic impacts. That is our complaint.
You said the commissioner, but you're saying it's the secretary who would require it in the Section 61 findings.
No, it's the commissioner who makes the Section 61.
Who makes the findings,
yes,
but the
permitting
requirement
agency
comes from the secretary, doesn't it?
The requirement is from the statute that any permitting agency issues Section 61 findings to support a permit. Now, suppose how could Canton have filed that lawsuit before the Section 61 findings by the commissioner were issued? Suppose we had filed it. back when the sewer connection permit or the beneficial reuse determination was
Well, you
made.
file the lawsuit, and then you can flesh it out later on. You at least file it.
What could we have said, Your Honor?
That there are going to be traffic impacts on the town of Canton that are adverse.
But you don't know.
Unmitigated by Section 61 findings? The Section 61 findings hadn't been issued yet.
But don't the Section 61 findings follow what is in the FEIR in terms of what the Secretary said?
Certainly not, Your Honor. They did not hear. The Commissioner is an independent permitting authority. She imposed many requirements of mitigation that were in excess of those that were stated in the certificate on the FEIR. We had something between an expectation and a hope that she was going to impose those requirements that we regarded as necessary.
But when you filed your notice of intent, it was about the FEIR, right?
It was, you are required
Right,
to
I
file a
understand
notice
that.
of intent about the FEIR.
Right.
And we said.
But it was about traffic and how it was addressed in the FEIR, right?
It was about traffic, and if the Section 61 findings did not expand sufficiently beyond what the Secretary had referenced in the FEIR, that there would be insufficient mitigation.
Well, you could file that could be a lawsuit. You can always withdraw your lawsuit later if the mitigation requirements are sufficient to meet your needs.
But how does it further the end of expedition if we file the lawsuit and the court can do nothing with it until, in fact, the administrative process is completed when the Commissioner makes her Section 61 findings? What could a court do? The court could either wait until we actually file the lawsuit so nothing would be advanced, or the court could substitute its own views for the expert opinions of the Commissioner.
But the filing of the lawsuit would have the value of putting the developer on notice that you are opposed to the project and that it's going to have to meet these objections. And if there's no filing of a lawsuit, the developer can go along and believe there's no objections.
We had already given them that notice by filing our very particularized notice of intent to sue. We said, when these things happen, we intend to sue. When and if they happen, we intend to sue. They were on notice.
But isn't there then a problem with your argument? Because you said we gave notice, we intended to sue, and if we follow the 30-day first permit, then you follow through and say, okay, we're going to sue. And it may be that you may have to wait, but you have to either put up or shut up with regard to that particular
But we
project.
didn't know whether we were in a position where we had to put up or shut up. As I said, we had something between a hope and an expectation that among the additional mitigation the Commissioner would require would be the mitigation that Canton regarded as adequate. Had the administrative process come out that way, there would have been no lawsuit. That the rule they are advocating that was adopted below would cause unnecessary lawsuits to be filed.
Are you without good basis for filing the lawsuit? Without a good faith basis for
I
filing?
cannot imagine. Well, I have a rich imagination, Your Honor, but I cannot see the how we could have maintained that lawsuit. The most permissive jurisdictional basis for the lawsuit is Chapter 214, Section 7A, which does away with ordinary notions of particularized harm in standing. But in order to maintain that lawsuit, you must allege that environmental harm is occurring or about to occur. That was not the case until the issuance of the Section 61 findings. This Court has ruled on a couple of occasions that...
Not so, though. You gave a notice of intent to sue, so you must have anticipated that damage to the environment, detrimental to Canton, was about to occur.
Well, the Court has said that the Secretary's certificate is not a sufficient basis for an allegation that damage to the environment is occurring or about to occur. And nothing that occurred after the Secretary's certificate and before the issuance of the Section 61 findings by the Commissioner gave Canton a basis for alleging that environmental harm was occurring or about to occur.
The relief you need, isn't it best given by the legislature? They've written a statute that you don't like, but we're supposed to enforce it, and it's quite plain, particularly when compared to other parts of the statute where notice is a prerequisite, and it isn't here.
Your Honor, we are not saying that you should infer a notice requirement, although there is one that we were entitled to notice of the Section 61 findings. We are saying that the first issuance of a permit should be construed to
mean the first issuance of a permit on a matter with which you are concerned.
that is issued in compliance with law. Okay. These first two permits were not issued in compliance with law. The court should not.
No, you're not saying that.
Yes, I am, Your Honor.
I mean, we'll say there. I thought you were saying it was a permit that concerned a matter that you were concerned about.
You gave two. You gave a two-part.
Yes.
You gave two parts.
First, those two permits did not enable us to make an allegation that environmental harm was occurring or about to occur. Second, they were issued in violation of law because the CCF did not provide to the Secretary.
Right. I understand
Yeah.
that, but your real argument is even if they had been issued in compliance with law, the Secretary gave notice of the Section 61 findings, you still would say you could wait until the Highway Department
That's
acted.
absolutely correct, Your Honor. We think we win on either ground, and the court should
And your point is, as I understood, with respect to the second one, not the subject matter at issue, was that you shouldn't, that there's something unjust about permits that have been issued not in compliance with law, that you can bypass the statute that way. I mean, I took them as two separate, both applicable in this case.
That is exactly correct, Your Honor.
Okay.
Thank you very much.
Thank you, Mr. Stevens. Mr. Wilkins.
Good morning, and may it please the Court. My name is Douglas Wilkins, representing CCF, which is the project proponent.
Could you please explain why the town should be required to file a suit when they don't know yet what the mitigation requirements are going to be, and the mitigation requirements, once the permit for the highway traffic is issued, the mitigation may satisfy them?
The reason that the town had to file the suit is because this is a lawsuit about the adequacy of the FEIR. It's not a challenge to the permit. And the legislature has been clear on the issues involved in this case that one must sue to challenge the FEIR before the first permit. Now, it is certainly...
After the first permit is issued.
I'm sorry, 30 days after the first permit is issued. And the legislature could have chosen a different rule. I wouldn't argue that this is unconstitutional to choose a different rule. But the rule the legislature chose makes a good deal of sense. The reason that it makes a good deal of sense is because the permitting agencies themselves are going to look to the FEIR. And if there is a defect in the FEIR, it's certainly to their benefit to know that there is such a defect.
But
and
Mr.
in this
Wilkins,
case, I'm sorry, but in this case illustrates the point quite well. Yes, Canton may have had a hope, something between a hope and an expectation that they were going to get more out of Mass Highway than they got out of the Secretary. But the legislature was within its rights to conclude that most agencies are going to include the same mitigation that the Secretary did. So we should resolve this first. It's a policy call for the legislature, and they made it in clear language here.
Is there anything in the record that indicates that most agencies do include the same mitigation as the FEIR?
No, I'm suggesting that was a rational thing for the legislature to assume in adopting the clear language, and nothing turns on whether that fact is in fact true or not.
But what could Canton, let's say they didn't want to challenge the FAIR, but they do want to challenge what the Mass Highway Department does in its Section 61 findings. Would you say that they are foreclosed from doing that because they did not file within 30 days of the earlier permit?
I think they are foreclosed as to issues that were resolved in the FEIR that they could have challenged.
Just say that again slowly, because I was listening
They
carefully.
are foreclosed as to issues that were resolved in the FEIR. One of those issues, for instance, would be...
Let me just... I think the issue here is, are you going to expand the highway, am I correct, or build a bypass? Is that...
Correct. There's some highway improvements that Canton wants.
So are you saying that the FEIR didn't provide for that?
Well, the FEIR said that the mitigation that CCF proposed, plus some additional mitigation that the Secretary imposed, more or less over CCF's objection, was sufficient to meet the requirements of Section 61 that all mitigation measures be taken.
That's for environmental purposes, right? That's for environmental purposes or just for,
Well, that's for purposes of
for me,
Section
I mean, for
61.
MEPA purposes?
So I don't think that having missed the deadline for challenging that finding by the Secretary, Canton can then come in and say, sorry, Mass Highway, your mitigation is inadequate under Section 61. Canton is barred from doing that. In fact, conceded that below.
What do you mean, excuse me, Justice.
Go ahead.
What do you mean conceded that below?
We had a colloquy with Justice Fabricant about whether there were two counts in the original complaint, and there was a colloquy that count 2 was not going to be a vehicle for a backdoor challenge to the FEIR, meaning that they couldn't challenge the mitigation that way. So I don't believe that's a contested point.
So you would say they could, if, for example, they didn't challenge the FEIR, but there was something, they could say, for example, that what Mass Highway did didn't meet the FEIR.
They could say that, yes. I think
I mean,
that's right.
theoretically. Or they could
that
say
claim would not have arisen.
or they could say that something Mass Highway did was inconsistent with the FEIR, or something like that. I mean, if there were independent grounds for challenging Mass Highway, you'd say they could do that after Mass Highway does its 61 findings. What they can't do is challenge those 61 findings on any ground that was covered by the FEIR.
Yeah, I guess I'd say it slightly differently, because those claims that could have been made at the time that the statute ran had to be made at that point. They're mandatory for inclusion. If something arose after that point in Mass Highway's decision, which didn't exist 30 days after the sewer connection permit, then I don't see how they would be barred.
So the permit that was issued by the Mass Highway Department, or assuming that a permit is issued by the Mass Highway Department, it may be separately appealable on other grounds.
That's conceivable, Your Honor. It's kind of hard to see what else is out there, but I certainly wouldn't
that's
say
another,
that it's gone forever.
Another way of asking that is there something that Mass Highway looks at that the Secretary does not look at?
Well, sure. I mean, it looks
Traffic
at a
safety.
number of highly discretionary decisions
I understand
regarding
that.
the use of state highways, and certainly we think that it's reasonable for the legislature to conclude that those kinds of decisions can be separately addressed, but should not be an excuse for delaying suit on the FEIR, because the FEIR does resolve a lot of the core issues in this case.
So stated differently, whatever the legislature with respect to the FEIR, if there was a claim that in some respect, some aspect of this highway approval was not covered by the Secretary wouldn't normally look at that. I don't know if the Secretary looks at, I don't know, overpass at 90 degrees. I have no idea what she does or doesn't look at, okay? Is it a she still?
I think it is,
The
yes.
Secretary is a he.
I don't know.
Oh, the
Sometimes.
Secretary. I was
The
thinking the
Secretary is a
Commissioner.
he, the Commissioner is a she.
The Commissioner is she. I was thinking the Secretary.
But let's say the Commissioner looks at something completely different. Whatever highway folks look at as opposed to MEPA folks,
Yeah.
it can't be that somebody who's aggrieved by that has given up all rights, no matter what the statute says.
I have to concede that, Your Honor.
So it's a case by case determination, and you say in this case their complaint was in fact covered by the FER and should have been obvious at that time.
Well, I mean, what I say is that the FEIR challenge had to be made. What the consequences of that are going to play out over many hypotheticals in the future. But if it was in the FEIR, it had to be challenged within 30 days of the first permit. That's the clear legislative language.
Well, can you play that out a little bit? Let's assume that they had filed within 30 days, say, of the sewer permit.
Yes.
They go before the court and they say, we're not complaining about the sewer permit. We're complaining about what's going on with regard to highways. Can you then move to dismiss because the matter is not ripe yet?
No.
Okay, so you're saying that part of what you're saying we should do is say this matter, although not ripe, can go forward. How can it go forward until we have 61 findings?
Oh, it is clearly ripe, Your Honor. This is a 7A. This is brought under 214-7A, which is not particular to the interests of the plaintiffs. 7A is a private attorney general statute, which is predicated on environmental harm. And this Court has held since the Massport cases and reiterated in Cummings that environmental harm is about to occur when a project proponent has got a defective FEIR and is proceeding. And the link that this case gives, the previous cases didn't, was defining when that first permit is. But it's not a hard question if you just look at the language of the statute. The only ambiguity in the statute is, was the BUD a permit or not? But that's immaterial to this case because either it was or the sewer connection permit was.
You don't have to reach that because
Correct.
it's even more untimely if
But
that was.
if you say that the environmental harm is about to happen, but isn't the reason that the Secretary can't be a party to that suit is that his decision doesn't cause the environmental harm itself? It's
That's
actually
right.
what meant when Mass Highway.
No. It's the proponent going forward on a defective FEIR is what
That's the defendant in this case.
correct. The
it's Canton
primary
against-
defendant is the private proponent in this case.
So it's Canton against CCF. It's Canton against CCF. The case, that case is Canton
Case would be
against.
Canton against CCF, and if they wanted to join DEP for acting on a defective FEIR, I don't think that would be dismissible either. But the reason they can sue is because we are moving forward, and it's our project that they allege will cause them harm.
And should the timely filed action be stayed until we get Mass Highway to make their
I think that's going to be a case-by-case decision. I think since the core issue here that still has not been, I mean, keep in mind, the Mass Highway decision here is only Section 61 findings. It's not even a permit. So it would be good to know up front whether there's something wrong with this FEIR, whether the mitigation is sufficient or not, rather than find that out years down the road, which is going to cause all sorts of project delay, problems with our financing. I mean, I haven't gotten into the parade of horribles about what delay does and repeated lawsuits do to a project like this when you're trying to get financing and tenants.
Yes, of course.
You had an obligation, am I correct? I think maybe it's the Attorney General says this, that you had an obligation, along with the agency, to submit the Section 61 findings so that they could be published in the Monitor, correct?
Correct.
And that didn't happen, right?
Correct.
So why doesn't Mr. Stevens have a point that in this case, whatever may be true otherwise, because you didn't comply with your own obligations that would have provided notice, why is that irrelevant?
It's irrelevant because, apart from the fact that Section 61 findings are not the permit that the statute talks about, there's nothing in the statute that turns upon notice, unlike many other statutes which do turn upon notice, and indeed portions of 62H turn upon notice. And like the zoning case, like Capuccio, for instance, even if there's a defect in notice, the plaintiff here was on notice that there would be a decision and was on a duty of inquiry. The statute resolves who bears the burden of error, who bears the burden of delay, who bears the burden of lack of notice. Some statutes place that burden upon the party who should give notice. Some place it upon the plaintiff. In this case, this statute is clear. There's no notice requirement. The burden is on the plaintiff, and they have means to inform themselves.
If there's no notice requirement, if I agree with you, which I agree with you, that there's no notice requirement, does that translate into a burden of inquiry on the party seeking?
Correct. It does. And
In all cases?
yes. And that's been true in zoning and other contexts as well.
Okay. Thank you, Mr. Wilkins. Mr. Clay, good morning.
Please, the Court. Pierce Cray, Assistant Attorney General for the Commissioner. I would agree with Mr. Wilkins on the last point in response to Your Honor's Chief Justice's question about the notice. The legislature is very clear. There are 4 separate deadlines in Section 62H. 3 of them run in whole or in part from notice of some specific event. This one does not.
Okay, let me just ask you, please. The agency failed to file a copy of its Section 61 findings with the Secretary. That's correct?
Correct, Your Honor.
Okay, so just if the Secretary then required the agency, DEP, to reconsider the sewer payment permit because of their failure to file the findings, then would the statute of limitations start again for Canton?
If ultimately there were, it would depend on the specific remedy imposed by the Secretary. But if the permit, the specific language is in the regulation is it could require CCF to require the department, DEP, to reconsider the agency decision. And if it does, I mean, that would
That would delay them. Yeah.
That could. I should just note, one for the record, I'm not sure if it's been brought to the court's attention before, a little less than a month ago, the town of Canton did file such a request. It's been vigorously opposed by CCF, is currently under advisement now by the Secretary.
Now, is your idea that the statutory deadline is 30 days from the issuance of a permit which is referenced in the FEIR, or 30 days from any permit, regardless of whether it's referenced?
The proposal that we are suggesting to the court
Don't propose. Tell me what the statute says.
Sorry, Your Honor?
Don't propose. Tell me what the statute
Our
says.
view is the statute should be construed in Justice Gant's first formulation. And more specifically, it should be a permit that was considered in the preceding environmental reporting process. Two earlier parts of MEPA, Section 62A and 62B, make extensive references to permits in that context. Permits trigger MEPA in the first instance. There's a requirement that the permitting agencies consult with the Secretary in the reporting process, and there's a requirement that the final environmental impact report be given to all the permitting agencies so it can influence their permitting, their ultimate permitting decisions. That's the very purpose of MEPA. So our position is that it's reasonable to construe the term permit in Section 62H as meaning one of the permits that was the same permits that was involved in the environmental reporting process under the two earlier parts of MEPA.
So any permit listed in the FEIR?
Yes,
But then you're adding words to the statute also.
No, our precise position was actually not listed in the FEIR, but listed in the Secretary's certificate on the FEIR. That's really, we use that phrasing really as a proxy for being substantively considered during the environmental reporting process as was contemplated by 62A and 62B. So we are really focusing more on the actual consideration in the preceding environmental process. And to the extent the listing in the certificate is a practice the Secretary engages in, provides a convenient shorthand memorialization of that, we pointed to. But our more important underlying concern is consideration.
But why should we amend the statute to add those words?
We're not asking you. Those words appear, we feel that is a reasonable construction of the term in 62H in light of its prior use in two earlier textual parts of the statute, 62A and 62B. So we're not adding language to MEPA as a whole. It's an accepted canon of construction to construe a specific legislative term in the context of the broader statutory structure, and we would invoke that canon here. But we should know what's the Commonwealth's overarching position is, above all, the Superior Court was clearly correct in rejecting Canton's proposed construction of the first permit that it claims injury from. That, without question, would fly in the face of the unequivocal purpose of the 1977 amendments that I believe Justice Cowan or Justice Botsford referred to, which was without question, as the courts made clear on two occasions, to expedite the environmental approvals.
What is your, I don't think I quite understood your position about statute of limitations for purposes of 214-7A. I didn't quite get it.
Oh, okay. In terms of what we're also, Canton has made the argument that it can't be, it was required to have sued when the Superior Court said it did, because it wouldn't have been ripe at that time. It wouldn't have had standing or ripeness to be able to do it. We are certainly not seeking a result of it's not ripe until it's moot. To the contrary, we encourage the court to make it clear that Canton could have sued at the time the first permit was issued under Chapter 214, Section 7A. That would create a very clear 30-day window of suit that would inform all environmental practitioners as to when it's okay to sue and when it's too late to sue.
And is Canton can do that because 214 has a town such as Canton as sort of, I mean, if you were an individual and a butter, I mean, some of these other plaintiffs in previous cases, could they do that also?
If they have 9 others who agree with them that there is environmental harm, it's either a municipality or 10 citizens.
Mr. Clay, are you suggesting that our law was not clear with respect to that
I'm sorry.
Oh, were you? I'm sorry. There's something wrong with my mic. Were you suggesting that our law previously has not been clear that, in fact, it was appropriate for somebody to bring this lawsuit, a town to bring this lawsuit?
The court's prior decisions didn't specifically consider the statute of limitations, the provision in Section 62H. They were more, the Sierra Club was more focused on when the suits could be brought. We're saying this is the case which now presents both of those issues in tandem, and we would urge the court to construe the both of the issues together so that there is this clear 30-day window that's created. Again, there is a paragraph in Sierra Club that's noted, but that paragraph, even if it bears the reading that Mr. Stevens gives it, was dicta, and again, the court did not have Section 62H in front of it. Now it has both issues, and again, our position is that one should be reasonably reconciled. Specifically, the language in Section 7A that we rely on is damage about to occur.
Yeah.
Our position is that it's the development itself that causes the environmental damage. There's a continuum in the actual development from design to construction, and it's a reasonable interpretation of Section 7A to say it's far enough along that continuum to be, quote unquote, about to occur under the meaning of Section 7A when the first permit's issued. That would construe the two statutes harmoniously together and again would produce a clear 30-day window.
Mr. Clay, I'm sure you think you've answered this, and you might have, but just to, I understand what you're asking us to do, and it seems to make sense, but if, in fact, the real, take the Mr. Stevens' between expectation and hope, are we, I mean, we are very overloaded in the courts of the Commonwealth. Are we, in essence, going to be churning cases where the real fight hasn't yet happened because the commissioner could obviate it? In this case?
No, Your Honor, because it's so important to see that in the whole environmental approval scheme, there are two basic types.
Right.
There's environmental reporting, which is concluded here. That concludes with the Secretary's certificate. Then there's environmental permitting. That's just getting underway. Here, the legislature made a clear decision that once the first of those two, the environmental reporting, is concluded, lawsuits challenging that, specifically the Secretary's sign-off on the EIR, need to be filed promptly. Perhaps when one's sued, it could be stayed in a particular case, but also the legislature may well, I mean, it also can be proceeded forward. There are two distinct sort of acts.
And would you make this, would the Commonwealth make the same concession that Mr. Wilkins made, namely if, in fact, there was something in this case in the Commissioner's requirements that was not addressed by, was not included in the review of the MIPA reporting or any of its certificate, that these people would then still have standing?
Absolutely. In terms of what the 62H is very clear. It's challenges to a determination that the EIR adequately and properly complied with MIPA. To the extent it's that specific challenge, whether it's into a permit or to subsequent Section 61 findings, that's precluded. But other permits are there for would be there. So we certainly agree. Section 61 findings are different ways. I believe Justice Bosford gave some hypotheticals that would not involve that specific thing. That's all we're asking for. But it's a major part of the whole environmental approval process, and we feel the legislature clearly said it needs to move forward expeditiously.
Thank you, Mr. Clay.
Thank you, Your Honor.